request of one of your members, we will recess tomorrow at 3 o'clock. But again, you know how my memory is, so remind me. At this time, the people may continue.
Just before the break, I was talking about the double life that the defendant was living in 2016 and through January of 2017 before Fabio's murder. And we talked about the fact that she wanted to be able to live full time with her lover, her soulmate, travel together, and then we saw the evidence of the lengths that she went to in order to get that life. And then if there wasn't already enough evidence of all of this, then during the most painful, heart-wrenching days for anybody who loved and cared about Fabio, she was busy taking graphic sex photos of herself that she then sent to Baker. And I would state that certainly anybody with any degree of care for Fabio would not have been doing that during that particularly solemn time. Yet, what you heard was this implausible, ridiculous tale that they tried to spin, that somehow Robert Baker, who's about as bright as a rock, managed to extract sufficient information, sufficient, specific, particular information from the defendant without her knowledge, without her assistance, and through a long series of what would then be, I guess, coincidences, he managed to figure out exactly when he could get Fabio alone. Not just on one occasion, but on two. I don't know if any of you people engage in gambling or betting, but I don't know that that's a gamble that one would take without having that information. And to also have to believe, you'd have to suspend all disbelief that the defendant never suspected Baker was involved, and that she still didn't believe it when the LAPD tell her, we found Baker's DNA all over the crime scene. And what does she do? What does she do next? She comes up with an excuse to explain it away. And then you also heard not only the attack, as I said, on the witnesses who tried to help the defendant and then realized they had been betrayed, but also on the LAPD and on their investigation. And that somehow the LAPD were so biased against this woman, and that there was a rush to judgment because they were having an affair. And you heard that same tactic through 4 different sets of investigating officers. And each of them, Detective Verna, retired. Detective Gable, retired. Detective Roberts, retired. Detective Farrell, still on the job. They all told you the same thing. They were willing to investigate as long as it took to make sure that everyone involved in this murder conspiracy is brought to justice. And they may never be done. And you heard questions about that. And the judge is going to instruct you about if anybody has any issues or questions with respect to any other parties who perhaps have not yet been brought to justice, how you are to treat that evidence in this case, and that is not necessarily evidence of anything. But in this case, despite the argument that all of these homicide detectives from LAPD just went out and arrested the defendant because she was having an affair, what you also heard, one after another, testify to was the mountain of evidence that they produced throughout the course of their investigation. You heard Detective Roberts, I think she reiterated again yesterday on the stand, over 220,000 pages of paper reports, over 8 terabytes. I don't know how many of you are computer people. 8 terabytes of data. Some computers don't even hold 8 terabytes. But the defense wants you to believe that somehow law enforcement just decided to arrest and prosecute the defendant because of an affair. If that is the defense in this case, then I sat through a very, very different trial. And in this case, you also heard the attacks on the opposite side. Well, why does it take you so long? Why don't you just run up to Alaska and arrest Christopher Austin? If you had information that he was in town, even though you don't have any evidence connecting him to the murder, you have evidence that he's connected to Baker, and there's flight records showing he came into town and then he left. Why don't you go up and arrest him and then ask him some questions? Well, that's not how it works, as you heard. Detectives are going, good ones, are going to take their time. As you heard from Detective Verna, they're going to build their case. You heard about Deborah Obad yesterday saying, well, I called Parshall like 50 times, and I said, go investigate this person, and go look at that person, and run this plate, and that's not how it works. There has to be evidence, and they build their case. And they're not going to tell the defendant or Miss Obad or anybody else in the public. They didn't even tell, as you heard, we brought in Jim Duggan. He was the security officer, the chief security officer for Cody out of New York. And when Fabio was murdered, he was brought in to make sure that it didn't have anything to do with the corporation. And one of the things he did is he reached out to Detectives Verna and Parshall. And what did he tell you? He said, well, like any other good detective, they were very tight-lipped. They weren't going to tell me anything. They'll listen to you. They'll take your information. But they're not going to tell you what leads they're working. They're not going to tell you what angles they're looking at. They're not going to tell you what search warrants they're serving. They're not going to tell you who they're interviewing. That's not what a homicide detective or any good detective is going to do. They're going to bide their time. They're going to build their case. They're going to make sure that before they accuse somebody, that they have the goods to back it up. And so, you heard about that through 4 sets of investigating officers who all told you the same thing. Now, one of the other things that you heard in this case is that the defendant is somebody who uses other people. She uses other people to do her bidding, to do her dirty work for her. That includes her daughters. You heard in this case that she had Jessica lie to her father by promising not to tell him when Jessica found Baker sleeping in her mother's bed when Fabio was away on a business trip. And you heard that on February 21st, when Detective Parshall and Detective Verna interviewed the defendant at her home, that they also separately interviewed Jessica. And Jessica was the first one who brought that up to law enforcement. And yet, when they talked to the defendant, remember, tried to downplay her relationship with Robert Baker. Also, after the murder, remember, the defendant used Jessica to lie to family and friends who were calling to check in on Monica and the girls, to check on their welfare, because they were worried about them after the murder. And so, what does the defendant tell Jessica? Tell them I'm asleep. Tell them you're just hanging out. When in reality, we know the defendant's out at bars and comedy clubs and partying with Baker. You heard from Melanie Garibay. Melanie Garibay, as you recall, worked for Wella. She was one of their show directors for these large corporate events that they would put on in places like Los Angeles or Vegas or other places around the country, and that the defendant lied to her and told her that Fabio knew that she was planning a trip to Las Vegas in March. And so Fabio had told her to get in contact with Mel, and Mel would get her a deal on a suite. Remember that? And clearly we know that the defendant and Robert Baker were planning these trips even before Fabio's death, because you heard and saw Baker's Facebook message to Ron Ray, where he said he and the defendant, this is in, again, November of 2016, are coming to Las Vegas soon, so he can introduce her to them and they can all hang out together. You also heard from Sal Macheri, who was the CEO at Wella, and then Cody. You heard from Dave Diaz, also was Fabio's boss previously through Wella, and Henry Meyer, the HR director for Wella for North America. And you heard how the defendant used their relationship with Fabio, with her husband, and played on their grief, their sorrow, because they were close with Fabio, to get them to do things for her, including things that they put into place as Henry and Sal Macheri talked about, things that the company had never done before that they believed were exceptional, like paying somebody's widow 6 months' salary, extending health care for the entire family and benefits for the family for 6 months, writing off a $9,000 company car loan on the car that, the truck that Fabio had. And you heard about all of the things that were done in the aftermath of Fabio's murder to try and ease some of the burden on the defendant. You also heard from Sheila Salahian. Remember, Sheila is married to Ricardo, and they traveled together. They went on dates, double dated together. In 2016, she and her husband were friendly with the defendant and Baker through the racquetball league. And we heard that the defendant used her as a cover, so that when Jessica found Baker sleeping in her mother's bed when Fabio was away, the defendant lied to Jessica and said, well, Sheila and Rob were both over the night before, and they both had too much to drink, and so they couldn't drive home. But we know from Sheila's testimony, she never spent the night at the house. In fact, she told you that the only time she had ever been to the house was, I believe it was the Wednesday or Thursday after the murder, where she saw Baker for the first time at LA Fitness, and he told Sheila and Ricardo about Monica's husband being murdered, and asked if they would go over to the house with him and Matt to pay a condolence call. And that was the only time Sheila had ever been there. In fact, the defendant tells law enforcement the same, that Sheila's never only been to the house once, and that was after the murder. But she uses her as a cover. She also uses Sheila as a cover when she tells her daughters, or when she tells Anna, that she's going out to, as I said, karaoke is the big cover story, after the murder on night when they're invited over to Fabio's best friend's house, Ernie Valorano, and Anna's in town, and she won't let her sister come with, but she's going to go do karaoke with Sheila. Sheila told you she never went out, never did karaoke with the defendant. The only time she ever got together with the defendant is when they got together as couples, and always with her husband, Ricardo. And then you also heard how she used Ernie Valorano and Sam Pulera, Fabio's friends and colleagues, in order to get sympathy and support, and played on their emotions, as you heard about. They also provided other little pieces of evidence that we're going to talk about. So as I said, the defendant wasn't going to do the dirty work herself, right? She's not going to kill Fabio. But she knew that Baker would, because Baker is a stone-cold killer. And he's willing to do it, and she knows that he's going to find somebody to assist him, who's loyal to him, in order to kill Fabio. They needed somebody who was gullible. They needed somebody who wasn't particularly bright, would go along with the program, would not ask a lot of questions, somebody who would do whatever Baker asked him to do. We can call him, if you will, the patsy in this case. And Christopher Austin was the perfect choice, because once he was convinced to directly participate in the killing, Baker and the defendant believed he'd never talk, that he'd never squeal, he'd never say anything about what happened, because he would have skin in the game. It would take him down as well. What they didn't count on, what they didn't account for, which was between the time of the murder in January of 2017 and subsequent to that time, that he would meet somebody, that he'd fall in love, that he'd get married, that he'd have a baby, and that he would have a family who became more important to him than Baker. And so at that point, he was somebody who was willing to give law enforcement the details of what he knew, to come clean, because he knew they had the goods on him. On top of that, Christopher Austin, whether you believe him or not, has a conscience. And he feels bad. Does that matter after the fact? I don't know. But while the defendant and Robert Baker got what they wanted, which was Fabio dead and plenty of money to start a new life, possibly in another state or country, they were very arrogant and they made mistakes. And they went, as you heard, to great lengths. And perhaps you were wondering during the days in and out of the testimony of various witnesses, including Detective Mitzi Roberts, about all these little small pieces of evidence as I was putting in various pieces of paper and talking about things that were now going to connect up. And you heard me do some of that through the testimony of Robert Baker. But they went to great lengths to cover their tracks. And they went to great lengths to destroy evidence, such as deleting encrypted applications, as you heard, from their cell phone and all of its accompanying data, or their messages immediately after the murder, or the messages that went back and forth between the defendant and her husband on January 22nd, which if she had no part in what was supposed to happen on the 22nd, she would have had no reason to delete those messages. And then, of course, on top of that, you also heard the defendant make various admissions. And the judge is going to instruct you on the difference between what is a confession and what is an admission under the law. Confession being where somebody admits to all of the elements of a crime, an admission, a statement that perhaps infers guilt or admits to certain portions of a crime or something of that nature, and you're going to receive those instructions probably, as I said, tomorrow. But what we also saw, and as I mentioned at the beginning today, was that Baker and the defendant were like a two-person wrecking crew. Or as Baker said, and you heard this yourself, when they were in the court lockup, he referred to them as Bonnie and Clyde. Now, some of you might be a little young, but I'm sure the rest will fill you in. Bonnie and Clyde were famous for robbing people, killing people. There were a couple, and they were on the run, and so you hear Baker making comments about how he and the defendant are Bonnie and Clyde because they were destroying everything and everyone in their path, and you heard them in the back once again scheming on how they're going to explain away the evidence against themselves and how they have to stick together, because if one rolls on the other, meaning one talks or testifies against the other, they both go down. And you heard them talk about sticking to the program, sticking to protocol. Even yesterday, you heard that there were, from Detective Roberts, that there was approximately 60 hours of recorded conversations between the defendant and Robert Baker during the time that their case was winding its way very slowly through the criminal justice system. And that the case started out in Van Nuys, and that there were two dates, one of which was June 29th of 2017, and the next one I believe was August 7th of 2017, and after that the case was transferred downtown because they knew it was going to be this lengthy case. And so you heard them talking in the lockup back in June, subsequent to their arrest, where they discussed on June 29th that Baker saying stick to the program. And you heard yesterday, and maybe you weren't thrilled that you were going to be hearing even more recordings, but it was brief. But what I want to point out to you is that, again, we're talking about 60 hours altogether between the 6 dates where recordings were done in the lockup in conjunction with the Sheriff's Department. And out of 60 hours, in order to give you what the defense thought was beneficial, you heard what you heard yesterday. And even in that portion, you heard them talking about concocting a defense. You heard Baker talking to the defendant about sticking to the program. As Detective Gable, who previously was in the military himself and testified about that, when you hear protocol, that is a plan that's been discussed, where you put it into practice and it becomes the policy. It becomes the protocol. And that's the language, the type of language and the scheming that you heard from these defendants. One of the other things I wanted to point out to you, when the defense says to you at some point in their arguments that, well, you don't have the content of their messages between Baker and the defendant where they are communicating about a murder. You don't have recordings of their pillow talk where they're communicating about setting up Fabio to be killed. Remember something. You can prove a case, you can prove facts by various sorts of evidence. And the judge is also going to instruct you on different types of evidence. There's direct evidence, which is perhaps what you heard in this case, let's say from Christopher Austin or from Robert Baker, people who were present and can tell you what happened, what was discussed. Eyewitnesses, that's direct evidence. There's also circumstantial evidence, and most cases are proved by things like circumstantial evidence. It's evidence from which you can infer a fact or a circumstance. For instance, let's say in this case, the gal who was on the witness stand yesterday afternoon as a defense DNA expert. Let's say that she had tested the interior of those tennis shoes for what I asked her about, wearer's DNA. And let's say the evidence that was developed, the evidence profile that was developed from that swab of the interior of the shoe, the wearer's DNA, came back, let's say, to Jessica. That would be circumstantial evidence. Sometimes people believe, well, if you have blood evidence, it's DNA, that's direct evidence, right? No, it's circumstantial evidence. It gives you information from which you can draw another fact or a set of facts. And so you're going to be instructed on various types of evidence in this case, and you're going to hear that direct evidence and circumstantial evidence are equally valid means of proof under the law. And there are certain circumstances that you have to take into account when you're dealing with circumstantial evidence, which I'm also going to talk about today. However, what I am going to tell you, that I want to point out to you, we don't give killers a free pass because they're successful at destroying and getting rid of the evidence against them. You got to look at what evidence you have. But, again, the law contemplates various things. And one of the things that the law contemplates is that criminals would do just that. And you heard from various witnesses like Cyree, I know Detective Roberts talked about it. You heard about things like, you probably learned about a lot of things, so now when you start watching those shows at home, you're going to be correcting them. But you learned about burner phones, right? Some of you might have known what a burner phone was. Some of you might not. You learned about encrypted applications. Some of you might have known about that. Some of you might not. But again, the law covers the situation where you have criminals who destroy, conceal, and suppress the evidence against themselves. And you're told under the law, and I'll cover this too, that those are facts and circumstances that you can take into account. And it's called evidence of consciousness of guilt. When you have an individual who, let's say, is in the lockup, pending trial in a murder case, for acting together, and they are writing jail kites, letters to one another, and then you hear one of them, the defendant in this case, saying, now you got to flush it. And then remember that day when we were listening to the recordings and it was so loud because not only could you hear all the other individuals in the cell area in the lockup, but them talking over the other individuals. And what did you hear? You heard the sound of the toilet flushing repeatedly. And they would talk about, now you got to flush that. Oh, let me read this part. Okay, then flush it. when you have two individuals who are actively in concert trying to destroy the evidence that they are talking about and whispering about, all of that is conscious of guilt evidence. All of that is circumstantial evidence that you can take into account that obviously points to guilt, as does motive. You're going to hear that motive evidence is not required. That there are cases, criminal cases, where it's very hard to decide why somebody committed a particular crime. And therefore, as I said, the law contemplates these types of circumstances. And so what the law says is that if you don't have evidence of motive, it might point to the fact that the person isn't guilty. However, but it might not mean anything as well. So it kind of gives you both options. But it also tells you that if you have evidence of motive, that is something that you should take into account, because it also may point to guilt when you have evidence of motive. And in this case, when they get up, because I don't necessarily get back up and respond, nor are we going to do that. We're not going to get up and do this tit for tat, okay? So I'm going to spend my time now, and I'm going to tell you what I think is important, okay? And then when they get up, hold them to it. Because Ms. Stadel and I, we're not afraid of the burden of proof. In fact, we told you that during jury selection, which I know seems like eons ago. Hold us to the burden of proof. We don't shy away from it. The burden of proof in this case, the judge is going to instruct you on, is reasonable doubt. That means, again, what have I mentioned several times already today? Common sense. You know, if you look around amongst yourselves, and you've been together now for quite a while, and I'm sure you've all managed to get to know each other a little bit. You are a very diverse group. We have people from different racial backgrounds. We have people that do different things. We have people that live in different areas. We have people of different age groups. And so you all come to this room with experiences, some of them difficult, and you've survived them. Some of them you're still looking forward to, what's going to happen next. Some of you have children. Some of you can relate, some of you can't relate, but you come into this room with your life experiences. Don't check them at the door. When you go back there, bring your life experience with you. Because again, when you look at the evidence, you're going to look at it through your own lens, through your own life experience, through common sense. You all are sitting on this jury because of that. You have it, take it with you when you look at the evidence. And that's what I'm going to talk about again and again today, about how the evidence in this case is based on common sense. Because what the law tells you is that when you're looking at circumstantial evidence, again, evidence that's subject to two different interpretations. One, let's say, that's reasonable, and the other, that is not reasonable, not based on common sense, not based on evidence, but based on speculation or some possible or imaginary doubt. The law says, directs, that you must reject the interpretation of the evidence that's unreasonable and go with the interpretation of the evidence that is reasonable. Again, the law takes into account that you might have circumstances where you could come up with all sorts of excuses for evidence, for behavior. But you are required to base your decision on reason, on common sense. Now, I want to talk about Christopher Austin a little bit. I did tell you that I am not going to spend a ton of time talking about Christopher Austin because you not only got to hear him on direct, you heard about how he was eventually, when the detectives were good and ready and had built their case, taken into custody and what went from there. And then you heard him be recalled in the defense case, and you sat and listened for a day and a half to his proffer session with me, with Ms. Stagel, with the detectives. And where we asked him various questions, he gave us answers, he clarified some answers, he corrected us, he came back the second day and did the same. One thing I want to say about Christopher Austin that happened from minute one. Remember, this is a guy, like I said, his life changed dramatically between the time when he comes down as Baker's patsy to commit this crime with Baker. Whether he was paid or not, he was going to do whatever Baker wanted, right? And the time that he's eventually apprehended and taken into custody, where he's now living in Vancouver, Washington. He now has a family. So he has other things that are now critical and important to him. But the first thing that happens after 8 years almost, when he's taken into custody on his way to work, he's, I think, a juvenile probation or parole officer up in the state of Oregon at the time. And when he's taken into custody that day, he admits immediately. He does the opposite of the shuck and jive dance that you saw from Baker. He admits to personally stabbing Fabio Sementilli. He admitted it. You can't change that. He admitted it. It was recorded. He said it over and over. And at that point, he sealed his own fate. And you heard about that seatbelt ticket. Once he was ticketed in the rental car that Baker used, that was the nail in his coffin. But it wasn't that easy, apparently. Didn't come up under numerous inquiries. Finally, it comes up in the database when the detectives are looking in a particular database, and once they have that ticket, now they believe, with everything else they've managed to put together, that they have enough to go up and arrest Christopher Austin for this murder. And you heard that they got warrants to do that. And so what happens is Christopher Austin is arrested on his way to work. He has no idea this is coming, but he admits to it. He knows, he tells you, as soon as he got pulled over, he had a feeling that this is what it was about. It was going to come back and bite him. And sure enough, he tells the detectives that day, and he tells Miss Stagel that day, I stabbed Fabio. And so when the defense argues to you, as they did from the beginning, that Christopher Austin is a liar, but Mr. Baker is telling the truth, keep in mind how the facts, the reality of this actually went down. Because in this case, like I said, you learned about a lot of different types of police investigative techniques. One of the things that you generally don't hear about on television is a Perkins operation and what that means. And you've heard that detectives use this very powerful tool to solve some difficult homicide cases. They're limited in the type of cases they're able to use it in. But again, even before Austin meets with a lawyer up in Vancouver, Washington, he admits to stabbing Fabio. And he admits that he was brought into this by Robert Baker. And he explained that he knew Baker's girlfriend was involved, even though, as he said, he didn't know her. They weren't friends, as he said. They didn't hang out together. He didn't know much about her. He only knew what he knew from Baker. But he lays out from the beginning that he was brought into this conspiracy to kill Fabio by Baker and Baker's girlfriend. And then you heard that during the Perkins operation in Vancouver, Washington, he tells his cellmate, he doesn't know the cellmate is an undercover police officer. That's the whole point of a Perkins operation, that the motive behind the murder, remember this, was insurance money. Baker's denied that to today. But yet, what did you hear? You heard that Baker not only admitted in this court his guilt to count 1 being the crime of murder of Fabio, count 2 being the conspiracy to kill Fabio, but he also admitted lying in wait, and he also admitted murder for financial gain. He admitted to a special circumstance, which means he is going to serve a sentence specific to that special circumstance allegation of life without parole. But he wants you to believe he only did this crime because he wanted to be with Monica. So why did he admit to a special circumstance allegation of murder for financial gain? Christopher Austin tells you from the beginning, cellmate asks him, what was this all for? What was the point of this? Insurance money. How does Christopher Austin know about that? The only evidence in this case is that he learned about it from Baker. How does Baker know that Fabio Sementilli has life insurance? From the defendant, of course. Again, this is just common sense. Now, also keep in mind, as I said, that Austin was the only one, the first and the only one, to mention the life insurance proceeds. So, this is way before, as you also heard, he ever speaks to a lawyer, because he's never been in trouble before. He doesn't know how the process works. And once he speaks to a lawyer then explains to him how offering up a proffer session with the district attorney's office and the investigating officers would be in his best interest. Because he's now admitted to being a direct perpetrator, which I'm going to talk about. He doesn't do any blame shifting like you heard from Baker, who made up excuse after excuse after excuse and changed his story every single time he had the opportunity to do so over the course of, I think it was 13, because the last interview was during trial in March, last month. Austin gives up this information before there's anything on the table. And he asks them, I want to go home to my wife and kids. Miss Heather, will you let me go home? And what do they all say to him? You're not going anywhere, buddy. The only place you're going to Los Angeles. You're being extradited to LA to face charges. Because what did I say earlier this morning? 4 sets of detectives from LAPD told you that they're not going to be done until they arrest and prosecute everyone who was involved in this murder conspiracy. And you also heard Austin explain why he wasn't completely forthcoming immediately after his first arrest in his life, either to a cellmate who he didn't know, who was a stranger to him, or to the LAPD, or to Miss Stagel. He has no idea what's coming. And of course, that's understandable because we're not talking about Baker, who's been in the system, right? We're talking about Christopher Austin, who's never been in trouble, who's been told over and over and over again through his father and through Baker over the years that Baker's going to take care of him. Baker's going to watch out for him. He believes that. So he hasn't spoken to a soul. Even his wife knows nothing about this until this all came out. He has never spoken to a soul about what he did to Fabio Sementilli until he was arrested on his way to work almost 8 years ago. But again, what he doesn't do, he doesn't minimize his role. He doesn't do any blame shifting. He tells you, this is my fault. I did this. They brought me in, but I did it all on my own. Nobody forced me. Nobody threatened me. Nobody coerced me. I came to LA to do this hit. And he had every opportunity to minimize, because remember, had he said what Baker wants you to believe, because it means that he's not as knowledgeable as what he told you, if he was only what Baker said, which would be a lookout, he might have been looking at an entirely different sentence. He might have been looking at an entirely different charge. But that's not what he does. And that's why his statements are so credible, because he doesn't minimize. And on top of that, the other thing that you heard about and that you have as evidence, there's 3 different documents, sets of documents in this case. You guys probably know, just like any business that you might work for, there's a chain of command. Whether you're talking about if you work in a corporation, if you work for a company, there's always a chain of command. There are certain protocols in place. Unless you work for an unaccredited lab, then you can do whatever you want. But there are rules in place. There are rules in place for a reason. So that the rules are followed, so that things are administered fairly between individuals, so that the same standards are in place, so that you know that we're not cutting corners, that we're not just trying to get someone to say something, because that wouldn't be justice. That doesn't do anything for Fabio and his family. We want the truth. Not the truth until we throw you up on the stand and then you can say whatever you want and just pare it back. Oh yeah, we told you to tell the truth. We told you to tell the truth. We told you to tell the truth. You didn't 12, 13 times, but we're still going to put you on the stand. And maybe, just maybe, because you've been sitting here listening to the evidence day after day after day, so conscientiously, maybe you also figured out without me saying it why we didn't call Deborah Obad to the stand. We'll talk about her. But he doesn't minimize. And there's 3 sets of documents that prevent him from doing anything other than telling the truth. The first is his proffer agreement. He had to sign a proffer agreement with his lawyer, Mr. Aval, with me, on the record. We put him under oath. You heard that at the beginning of the proffer session. That goes up a chain. There has to be approval. There's all these different things that you heard about. And the proffer agreement says, hey, we used to refer to it years ago as your queen for the day, which means you give us all of the information, whatever you say here, we can't use against you unless you get up on the stand at some point in the future and lie, then we can use what you told us today to impeach you. In other words, like what you saw with Miss Obad, where we can show the jury that you're a liar. But if we are able to corroborate, meaning support, prove what you're saying is true by independent evidence, then if we believe you've provided valuable, truthful information, then and only then are we going to be like negotiating with your lawyer in a plea deal. But right now, we're giving you nothing. Like, you're basically taking us at our word. You're going to pony up the information. We're going to, through law enforcement, see if we can validate what you've told us is true. And then and only then, we might engage in plea negotiations with you. And so you heard about that. The second document in this case, you heard about his plea transcript. We put it into evidence. In fact, I'm going to give you a perfect example. This is a problem because, just so you know, I tend to go off script in a closing because I think of all these little pieces of evidence that I've had in my head for 8 years, and it just makes it longer. But it just means I'll skip other things as we go forward because I'm going to talk about it anyway. Think about Robert Baker, right? Robert Baker got on the stand and testified at the beginning that he didn't understand when he took his plea in this case. Remember that? Remember that? And so, what did that mean?
I object, Your Honor. That's not the
It's
evidence.
overruled.
Yeah, because basically what he was saying is Judge Cohen, who you've probably noticed, who's a stickler for rules and procedure, follows, again, a protocol. And he does the same thing every time when he takes a plea. And there's a plea transcript. Because Brooke, or a court reporter who sits in the courtroom, writes down everything, as you've seen, that gets said. And why do we do that? So there's a record. So when you hear somebody like Deborah Obad, who testified that she lied and perjured herself in front of the grand
Objection, Your
jury,
Honor. That's uncalled for.
It's overruled.
specifically testified that she lied to the grand jury, and you hear Baker get up and commit perjury where he says, I didn't understand what the charges were. No one told me. I didn't plead to that special circumstance stuff. What happened? I brought out the transcript. I put it on the projector. I went through it with him. Remember when the Judge Cohen, asked your lawyer, is this what you want to do? And then he didn't just talk to your lawyer, Michael Simran. He talked to you. He asked you specifically. He turned to you. He had a conversation with you. Sir, is this what you want to do? Do you understand that you have various constitutional rights that you are going to waive by entering your plea here today? And then he goes over all of the constitutional rights that Baker has to waive. So again, when Baker gets up on the stand and he tells you in an open courtroom that he didn't understand what he was pleading to, and he did it again, if you remember, when we got to his prior sex case, and I had to do it all over again. You'd think he'd be smarter and understand, I had the plea agreement from the transcript from this case, and clearly I was going to have it from that case, but flat learning curve, doesn't get better. So again, I'm asking him, do you remember when the judge turned to you and said, is this what you want to do, sir? These are the charges. How do you plead? Right? It's all laid out for him. He agreed to it in this courtroom on the record. That's a record. Right? So we have the plea transcript from Mr. Austin, also in front of Judge Cohen in this court, where we did the same thing, and the judge went through the same practice. These are your rights. How do you want to plead? This is the deal. Before they even admit to the plea agreement, and you can look at these because they're all in evidence. We marked them all. It's all transparent. Before he even takes the plea, the judge tells him, this is what the consequence of your plea is. Is that what you want to do? Your attorney has indicated that you want to plead to this, but is that what you personally want to do? Yes, it's what I want to do. Do you understand, Mr. Austin, that your plea agreement is based on your truthful and complete testimony at trial? Yes. Because if not, guess what? No plea agreement. And who makes that decision? The defense wants you to believe it's us. But I don't run the court. You've heard him yell at me. He runs the court.
Me too, Your Honor. Me too,
Anyway. So, the judge makes that decision. He has to sit and listen. And he takes notes. And he reads what's being said off his screen as Brooke is typing it. And then at some point later, Mr. Austin comes back before the court for sentencing. Sentencing gets put over, as you heard, until he's testified. And he's on the hook for testifying and cooperating with as many cases as it takes until they're done with everyone in this case. So the judge makes that call. And then there's a third document, and that was an agreement for testimony with our office. Before we put you on the stand, you agree that you're going to tell the truth. It's a contract. If you don't hold up to your end, we're going to ask to be released from our bargain, and we can go to the trial. And we'll pick a jury, and we'll see how it goes for you. Right? So there's different documents that are in evidence in this case that you can look at. So again, keep that in mind when they get up to argue. Now, I said I was going to talk about the law. I thought it was going to be sooner, but here we are. So, in this case, you heard, or you're going to hear, the judge instruct you, as I've said, about the applicable law, which is the framework for which you have to look at the evidence and make a determination on whether the evidence that Ms. Stagel and I have presented, whether we've proven our case, whether we've proven the elements of the crimes and the special circumstance allegations to the standard of law, beyond a reasonable doubt. And what the law says, that people who are involved in committing a crime are referred to as principals under the law. That's the term, principals. So who are principals? Well, principals include those who directly and actively commit the crime. So if we're thinking about who actively, directly, personally committed the crime, and we talked about how a stabbing is a very up-close personal crime. Who's wielding the knife? Well, in this case, we have Mr. Baker and we have Mr. Austin, right? They're the people who go to the crime scene, go to the house. They're the people who stab Fabio to death on the back porch. They're not leaving until that job's done. those who aid and abet the commission of a crime are also principals. Now, when I say aid and abet, what does that mean? Aiding is, I mean, that's an easy term, plain meaning, but abetting, what does it mean to aid and abet a crime? This is where the defendant comes in. You have to have knowledge of the unlawful purpose of the perpetrator. So in other words, that she knows that Baker and his co-conspirator are going to commit murder, the murder of Fabio. In addition to that, she has to have the intent or the purpose. What's her state of mind? Judge is going to give you instructions on state of mind and what that means for the various crimes and allegations. That she has the intent or purpose of committing, facilitating, encouraging, somehow aiding, assisting the crime. How does she do that? We're going to talk about this when we get to conspiracy. She does that by setting Fabio up, luring him into this false sense of security. And as I'm going to talk about this afternoon, by setting in motion this very, very short window of time, this timeline. Remember that PowerPoint presentation by Mr. Ed Cozen that we played through Detective Roberts' testimony where we laid out the entire day so you could see how all these things fit in and how short that timeline is? I think 418 joggers are just turning from Oakdale left onto Queen Vic. It's the second house up on the left, and they're out, pulling out of the Porsche at the bottom there at the intersection where the neighborhood surveillance cameras are about half an hour later. Very short. Got to get in, got to lay in wait, find out where he is, got to kill him, take him down. He's a big dude. Takes two. We'll talk about that. Got to then set the crime scene up, stage it as I talked about already today, and then got to get out of there and back, out of the area. Okay? So she has to have the intent or purpose to encourage or assist her intent, her mindset. And then she actually has to assist. And actually she has to do something. She has to aid them. Again, by setting this crime in motion, by telling Jessica, don't be late for babysitting, by looking at the IDMS Light app to make sure that Jessica's gone, that there's no one else there now in front. It's just Fabio alone. And then she aids, she promotes, she encourages, or she instigates the commission of the crime. So this is law the judge is going to give you. Feel free to take notes as I go through the law. I'm going to break it down. I'm going to talk about it in small pieces and try to make it simple for you. So again, when you go back into jury room and you select your foreperson, you will be able to have meaningful conversations right from the bat. Okay? So again, the judge is going to give you this law, and it shows you how you can be a principal, either as Baker and Austin did by actively committing the crime, but also those who assist those direct perpetrators in getting the crime into motion. Okay? Let's talk about murder. Count one. Murder is, as you can see, is fairly simple. It has three elements. A human being is killed, and the killing is unlawful. Okay? Human being, it's a done deal. Fabio. Right? Killing's unlawful. No-brainer. So malice aforethought, again, that mental state element. What does it mean to have malice aforethought? And what the judge is going to tell you is that malice can either be expressed or implied. You have implied malice in this case. If I usually would give an example of, let's say you're in a crowded park, someone shoots a gun into the air, it comes down that bullet as everyone would expect it to, and it kills somebody. Reckless disregard. Okay? this is obviously an implied malice case, but more than that, it's an express malice case. And so I'm going to spend a little bit of time talking to you about express malice. Express malice simply means intent to kill. And you're going to hear from the instructions that Judge Cohen is going to give to you that an intentional killing is sufficient for proof of express malice. We know in this case, Fabio was intentionally murdered. He was not stabbed. He did not suffer 7 sharp force injuries on his back patio accidentally. This was an intentional killing. That's murder. The other portion is a forethought, and that means that your intent to kill has to come before you kill him. That's, again, in this case, fairly straightforward, very commonsensical, based on the facts and circumstances. They knew when they went up to that house that they were going to kill Fabio. They didn't kill him and then decide afterwards, oh, it would be good to kill him. They knew what they were going for. That was the plan. That was the conspiracy. And that's going to lead us into the second count.
That's only time between now and 5 minutes from now. When you find a good place, let me know.
Perfect. I'm done.
I had a feeling that would work. We'll take our lunch recess till 1:30. Again, as always, the admonition applies not to discuss this case among yourselves or if anyone else or form expressed opinions of the cause is finally submitted to you. Have a good lunch.